Good morning, hello and welcome. By way of introduction, my name is Mark McCollum. I I'm from Donegal, but I was born in Marionvale, mother and baby home in Newry, and I was taken over the border and placed in an orphanage in Donegal. And I've been sort of searching and striving to find my identity for most of my life, and it's only in recent months that this has come to fruition. That it's timely that it's coming when the Northern Ireland we now have an opportunity to co-design an inquiry into the human rights violations that mothers and children have experienced. There were these were many and various. Some were documented in the recent academic report by Queen's University and the University of Ulster. Others merit and require further investigation and still have to be fully uncovered. A 6 month government established process of co designing the inquiry is now getting underway. This is our chance as victims and survivors of these institutions to determine the design, the powers, and duration and terms of reference of these investigations. Amnesty International and the University of Ulster have organised these series of online events with survivors and other experts from here and overseas to help us navigate this process and the decisions that lie ahead. I'm delighted this morning that we have a great panel to help us and advise us. We have Professor Anne-Marie McAlinden from Queen University Belfast, Colin McGorman from Amnesty International Ireland, and Frank Goulding from Care Leavers of Australia Network. I just want to talk for a second. Each contributor will speak for about 10 minutes, and then we will try and draw the strands of the conversation together at the end. It's an important time for us all to think about this, and there's a lot of learning that we can take from previous experience. So our first speaker, our first contributor is Professor Anne-Marie McAlinden. Anne-Marie is a professor of School of Law at the Queen's University Belfast. She's written about approaches to addressing historical institutional abuse by the Catholic Church in Ireland and was invited by an international experts to give oral and written evidence to the Australian Royal Commission into institutional responses to child sexual abuse. I think today she's going to talk to us about a possible hybrid model of truth and justice for survivors. Is that correct, Anne-Marie? Lovely to hear from you.
So in terms of my background and experience, as Mark has said, I'm an academic, so I have written on the dynamics of historical institutional abuse such as grooming, how abuse occurs in institutional contexts, as well as policy and legal responses such as restorative justice, and there's a couple of the key publications there. More recently, I've also done a large-scale empirical study on apologies with colleagues at Queen's, and part of that involved interviews with survivors across Northern Ireland and the Republic of Ireland, as well as legal professionals, church representatives involved in apologies. And as Mark mentioned as well, I've also given expert evidence and done consultancy work for the Australian Royal Commission, and more recently I've been asked to do the same for the independent inquiry into child sexual abuse in England and Wales. But it's essentially an academic perspective informed by empirical work as well with survivors and others. So in terms of what works, just briefly then, some of the important functions of public inquiry. So it's said to give a public record of events. Very importantly, it gives victims a chance to tell their story, though there are limitations to that. It's supposed to provide accountability, though I've put a question mark there because, as I'll come back to, there are difficulties with accountability for a number of reasons within the public inquiry framework. There can be difficulties. One of its chief advantages is the legal powers to compel witnesses and documents, so making the church cooperate, for example. And also it can make recommendations with a view to policy reform to stop it happening again. But overall, there are structural limitations which I'll come to, including a lack of a victim focus. So in terms of what doesn't work, the dominant model that has been used, for example, in Ireland, and there are variations, but the dominant model that has been used in Ireland and Northern Ireland, the Hart Inquiry into HIA and Australia, is this sort of two-stage process where you have the private acknowledgement forum, a confidential committee as it was called with the Ryan Commission, followed by a public investigation panel where you have all the trappings of adversarial justice. I mentioned the difficulties with accountability. So, for example, it's very difficult sometimes to capture the complexity of abuse and the multifarious factors in terms of how abuse occurred. So if you take the Catholic Church, for example, you had state and church complicity, you had organisational wrongdoing, you had individual perpetrators, as well as sometimes maybe the complicity of wider society or families in committing family members to institutions. So unpacking accountability and direct lines of responsibility is complex. The features of the adversarial model are crucial, as I've mentioned, such as lawyers and cross-examination in ensuring cooperation of the church, but that can have an impact on victims, and certainly some of the survivors I've interviewed spoke about the difficulties they faced in the HIA inquiry in Banbridge and the impact on them. And one of the biggest problems with inquiries is that very often they focus on the direct or primary victim only and not the secondary victim and the impact on families of survivors. Further, in terms of difficulties, the terms of reference are crucial, and I'll come back to this in terms of what that might actually look like. But the terms of reference, if they're limited, can limit what is known as a fuller or forensic truth. So, for example, many of the inquiries in the Republic of Ireland focused on state responses or church responses, what the church and state knew and when it knew it, or the level of church and state involvement in abusive regimes or institutions. That doesn't actually tell you a lot about abuse, how it occurred, and victims' experiences. So if the terms of reference aren't right, it can limit the understanding of the causes, context, and consequences of abuse. Another problem to be aware of is this idea of selectivity. So, for example, again, the Ryan Commission, while it did hear accounts from a wide range of survivors and a wide range of institutions, it only actually ended up reporting on a smaller number of institutions and survivor accounts where they reached a certain threshold or number. So that again doesn't take full account of victim experiences. Related to that, another difficulty is perhaps offender anonymity. So sometimes offender, church religious professionals, their names can be redacted or blacked out in reports. So again, in the Republic, the church brought an action against the government, and they wanted to make sure that anonymity was preserved for perpetrators. So again, that is not preserving the veracity of accounts, so that's an issue potentially. We also have lack of institutional engagement in some cases if the church doesn't cooperate, and there can also be lack of follow through. So in the Republic in particular, there's been a wide variety of inquiries, and many of these have made the same recommendations which have not always been followed through. And it's the same with the HIA inquiry, as we know, because of the executive collapsing, the recommendations of the Hart inquiry haven't been followed through. So in terms of the lessons learned, just to note, there's a wide diversity of survivor experiences and needs. And this is a very basic point, but it's one not to be overlooked. So while some victims understandably want prosecution as the end line to accountability, that doesn't always happen. We know there's been very limited number, if any, prosecutions from many of the public inquiries we've seen. Some survivors do want prosecution and punishment. Others simply want truth and acknowledgement, first of all, that the abusive experience happened, and access to their records. Identity is key, as Mark mentioned at the outset. Others want accountability, but it is complex and multi-layered, as I've said, in terms of how you unpack those direct lines of responsibility involving church, state, individual perpetrators, organisations and wider society. Others want recognition of the impact of abuse on their lives, so not only just the actual impact of abuse per se, but the longer term lasting effects of that, and also the intergenerational impacts too. Similarly, others want voice and empowerment and a role within the justice process, so some control, which is what we're trying to talk about today. What do survivors want? How can we make it victim-centric? Some, particularly secondary victims, want to sit down and actually talk with offenders. This is where the restorative element comes in. So I have had a number of examples where mothers of survivors, in terms of clerical abuse within institutions, wanted to sit down and actually get an apology from the church. Obviously, the individual perpetrator was long deceased, but they wanted some kind of forgiveness, reconciliation, as they saw it, from the church. But not all want that. Others want more tangible forms of redress and reparation, such as apology, compensation, enhanced medical care, counselling. And, many would say that ultimately what they want is to stop this happening to other people, so the prevention of further abuses. So this is probably one of the most important aspects of this to me, which is the terms of reference, their scope, and the definitions of the key terms that are used therein. So first of all, the term institutional is key. because institutional can cover a range of institutions. So you have the Magdalen laundries, mother and baby homes. In the south, for example, you had county homes. You can also have an extension into the community. So, for example, laity can be involved. You had girls who were pregnant who were put into Catholic homes in the community. Not all had great experiences. So how you define institutional is important. It's not just this tangible link to four walls. That's key to me. Harms and abuses is also important, again, encompassing the tangible and maybe the less tangible for some people. So it's not just about physical, emotional, psychological abuse. We know it's about, for in mother and baby homes and the Magdalen laundries context, it's about forced adoption, forced labour, denial of basic human rights and needs. So, for example, the denial of education, again, which has lifelong opportunities, separation from the family, and again, this loss of identity. How we define victimhood is also important. I've already mentioned the intergenerational trauma between families down through the years, the lifelong impacts of the abuse, how it affects even relationships with people, and also I've already said about the impact on not just primary victims and survivors, but secondary ones as well. So in terms of applying that learning, looking at the diversity of what victims and survivors want, what has gone wrong with public inquiries, trying to apply that learning then to think about things a little bit more differently and creatively in terms of considering a hybrid model. So the failure of adversarial processes, I've said, has come about in terms of failing to address the harms to the full range of individual victims. And restorative justice therefore emerges as a potential alternative, or as an add-on, if you like, due to the failings of formal adversarial processes. And I think this could be incorporated as an avenue within an inquiry rubric. And there's different ways of doing this we can maybe talk about afterwards when everybody has spoken. But one way of doing it is through this idea of mediated encounters, where you have acknowledgement of the harm from the perpetrator or a representative and an offer of reparation. Now, it won't work for all victims because there's safeguards have to be in place and all of that, which we can come back to. But crucially, it's not about fact finding. So it's not the way an adversarial process is, like an inquiry to find out what actually happened. It doesn't start from the presumption of guilt or fact finding. It's about reparation. The advantages of it, though, is it gives greater voice for victims and greater accountability. And also, it's been shown greater cooperation from offenders as well, if they know there are going to be no sanctions following this. So there are all sorts of difficulties there, as you just see when I explain the model a bit more in a moment. If you agree to do this, if the survivor and perpetrators agree to do this on an individual basis, then you may have to forgo prosecution in terms of the second element of the public inquiry. But it may work for some, but not all. So in terms of this flexibility I've mentioned within the two-stage process, so I've already mentioned that most inquiries take the form of a private acknowledgement forum on a confidential basis, plus the public investigative panel where lawyers are involved, which may lead to subsequent prosecution. So what I'm suggesting is have the first forum, have the acknowledgement forum, and then on an individual basis give individual survivors a choice to either choose the investigative panel, where they give their evidence in public, and the possibility of prosecution from that perhaps, or choose a restorative element. So it would be an either or, where you're sort of swapping out the sort of public inquiry aspect of it, the investigative aspect, with a restorative element. Very, very importantly though, it will not work for all cases. There has to be protection and safeguards. So cases will have to be carefully selected. There will have to be clear criteria for referral. It has to be consensual. There will have to be a balance of interests. There are all sorts of difficulties, legal difficulties in terms of what if a perpetrator makes an admission during that. So there are issues around immunity and things like foregoing prosecution. But so all that would have to be carefully worked out, and I can talk a bit more about that if it needs be in the chat part. But what the advantage of this is that it's about procedural justice. So this is the key to this for me, a hybrid model. It's about looking at the inquiry and what happens as procedurally fair and victim-centric. It's not just looking at the end goal in terms of what do we get out of this, in terms of an apology or compensation or prosecution. It's actually making sure that the process itself is procedurally fair for survivors. And this is where Daly's model of procedural justice comes in. She talks about, procedural justice, forms of redress for survivors of HIA, focused on participation, voice, validation and vindication of the survivor's experiences, and trying to ensure offender accountability. So I'll just finish by summing up what I've said. So it's highly complex. Survivor experiences and needs are diverse, they're not all the same, and we need to have a hybrid process that takes account of these various wants and needs of survivors. I think a hybrid model as well would allow you better to try and capture the complexities of individual, organisational, state and societal involvement. What the advantage of it is, it focuses on the procedural fairness for survivors and not just the actual outcome. So the process itself is fair. It's very victim-centric in terms of inclusivity and diversity. But to do this and to look at the hybrid model, we need to think carefully about the terms of reference therein, such as institution, victim, abuse, and the terminology around those. So I'll stop there. Thank you.
Okay, thank you for that, Anne-Marie. It's a complex issue, as we're all aware, and there's a lot of issues there that need to be teased out. And there is no simple one-size-fits-all solution to this. And what works for one may not work for everyone. So it's good to see different options. So, and leading on from that, there, thanks, and we'll tease some more of that out in the discussion, Anne-Marie. But I'd like to bring in now is Frank Goulding. He's speaking to us today from Ballarat in Australia. He's a former care home child resident and vice president of the Care Leavers of Australia Network, an honorary research fellow at the Federation University. And today, to this talk, he's going to discuss maybe some of the lessons learned from the Australian Royal Commission into institutional responses to child sexual abuse.
Thank you very much, Mark, and thank you for inviting me to participate in that. And I found the first session immensely interesting, a lot of resonance with my experience in Australia. I just wanted to say that the Australian Royal Commission, of course, was very much a large-scale inquiry with 6 full-time commissioners. And one of the strengths of that panel was that it wasn't just judges. There were 2 judges, and then there were 4 others who brought a variety of experiences, including one who was a former child migrant. So that makes it distinctly different. It was a massive enterprise. Next slide, please. A massive enterprise because apart from the 6 Royal Commissioners, it ran for 5 years, where initially it was meant to simply run for, thank you, next slide, please, run for 3 years, but it extended out to 5 years. It had a massive budget of 370 million Australian dollars, and at its peak employed more than 300 staff and contractors. It ran private sessions in 96 locations across this very vast Australian continent, and with inmates in 61 correctional facilities. Next slide, please. It was also a global event. There was live streaming, and it was viewed by 60 different nations across the world, from Argentina through the Vatican to Zambia. We know which hearings attracted most interest: the Catholic Church authorities in Ballarat, my hometown. It was the strongest case study in terms of interest in both Australia and in the USA and the UK. Most commonly viewed abroad were Jehovah's Witnesses and Watchtower Bible in the USA and Canada, which struck me as being quite a surprise. And the second most viewed internationally was the Yeshiva case study, which attracted great interest in USA and Israel. Next slide, please. I agree totally with the point about the importance of terms of reference. The terms of reference in this case were developed after a short consultation period. I think it was all stitched up beforehand. So people were given a week or 10 days to have comment on that. From a care leaver perspective, it was both too narrow and too broad. It was sexual abuse only. Other forms of abuse, which of course have been reported on at length in a number of countries, including yours, were excluded. And institutions range from everything to do with children except the family. It also had a mandate which was both historic and looking at the future. So the issues of what happened in the past were examined, and so was prevention and better responses into the future. Next slide, please. The three pillars are well known. It offered private confidential sessions, and there were something over 8,000 survivors who spoke directly to one or other of the commissioners. There were public hearings, 57 case studies with formal trappings in a court environment with witnesses following investigation by officers of the Royal Commission and preparatory research. And then there was a whole body of research and policy commissioned by the Royal Commission, 59 research papers, over 1,300 submissions in response to issues papers. Next, please. It's fair to say that the care leaver community was overshadowed, and the Royal Commission, unintentionally, I suppose, constructed hierarchies of suffering and tension. As I said, non-sexual abuse victims in care setting were sidelined for 5 years. They didn't get a mention anywhere in the Royal Commission nor in the media which attached to the Royal Commission. Even many sexually abused care leavers felt this wasn't their Royal Commission, it was somebody else's Royal Commission. Whereas nearly 50% of those who volunteered for private sessions were sexually abused in care settings, only 14 of the 57 case studies dealt with care settings, and only 17 of the 59 research reports dealt with care settings. And the question that obviously raises from that, will the hierarchy of attention flow on to the National Redress Scheme, which followed from the Royal Commission? Next, please. The Royal Commission made very good use of mainstream and social media. As I said, there was live streaming, which provided footage, and the Royal Commission provided footage to TV stations for news bulletins. The Commission had a web page, a Facebook page, Twitter and YouTube accounts which were actively used, and the Royal Commissioners were responsive to public speaking requests. They weren't sitting up on their benches all the time. They were out and about talking to groups, including CLAN, the care leaver community, on a couple of occasions, speaking quite frankly and openly about what they were doing and how people could get involved. Next, please. This it represents a picture of the overshadowing effect in the media. The media is voraciously interested in scandal and high-profile figures. So George Pell and the Catholic Church cover-ups, of course, dominated some of the discussion. I don't know whether you can see the points on that particular graph, which is a timeline of media interest, peaks and troughs. But points 2 and 5 represent the surge in media interest or coverage in the hearing focused on the Catholic Church in Ballarat, and the appearances by Cardinal George Pell, also in Rome, of course. If you compare point 5 in the graphic, the case studies involving Pell, 8,000 news stories. At point 2, 10,000 news stories. If you compare that with a case study in April 2015, nearly at the same time as this was happening, a Queensland orphanage case study attracted only 1,800 news stories. So there's a tremendous discrepancy between the interest of the media in some areas as against others. And that's the overshadowing effect that I think is really important to understand if you're going to involve the media. Next slide, please. The reports were released as they became available. It wasn't, we'll have this inquiry and then we'll report on it. There were a succession of reports, a plethora of reports, as you can see on that slide. The final volume was the final report comprised 17 volumes. One of the volumes had 3 books to it. So, and then there were various case studies reports, as I said, 57 of them, research reports. 2 of those research reports were redacted. Two of the case study reports, that's a mistyping on my part. 2 of the case study reports were redacted until George Pell's case completed in the High Court in April 2020, and we only learnt what was in that report after that date. So, but the reports were available as it went through. And if you look at the next slide, please, you'll see the same thing with the recommendations. There were 409 recommendations, but they didn't come out in one batch. They came out as the Commission was ready to report on them. So the redress and civil litigation report in September 2015 was produced because the Royal Commission considered that issue to be urgent. And so on it went. And prosecutions, 2,500 prosecutions were referred to police, prosecutions started during the life of the Commission, and many more have followed since then. Next slide, please. So this helped actually keep the story alive. I just wanted to make a quick comment about care leaver activism based on high visibility. If we were going to be sidelined, we weren't certainly going to let that happen without a fight. Next slide, please. So the care leaver presence and voice was characterised by good numbers at the hearings. We encouraged care leavers to attend those public hearings, to wear their colours of blue and yellow, getting the numbers to private sessions. A lot of people were cajoled, encouraged, persuaded to go to the Commission, but they always knew they would be supported by the care leaver organisations. And the direct contact with commissioners and key staff was very good. The Chief Commissioner really made the point, let me know if things are not going well, and we can talk about how they can be improved. So it wasn't a standoff situation. Next, please. Questions about what happens after the Royal Commission. There were two views developed towards the end of the Commission, and I've just represented them there. The Deputy Chair of the Catholic Church Truth, Justice and Healing Council, which was the organisation set up to coordinate the Catholic Church's response to the Royal Commission. She said there's a view that once the Royal Commission reports and the publicity around what will be a fairly dire report all dies down, that life will go back to what it was. Whereas Julia Gillard, who had set up the Royal Commission, as Prime Minister said at the end of the period, the public won't tolerate this report going onto the back shelf to gather dust. Well, it's a question of judgment as to which view is the one that actually has the most truth. So let's have a look at the next slide, please. The Royal Commission was concerned about this. I remember going to a forum in Ballarat where the head of the Royal Commission was asked this very question. How are you going to ensure that, like many other reports, your recommendations don't sit and gather dust? So they put in recommendations about monitoring the progress. So there were agreed timelines that the Commonwealth and state governments were to report, and that's been followed. Major review by the Commonwealth in 10 years' time, whether or not we need another Royal Commission because the recommendations haven't been implemented or they weren't effective if they were. The Royal Commission's kept its website accessible. The public can still order copies of the reports, the address there. A point of contention about the records the Royal Commission actually made, and they made thousands upon thousands of records. They've been archived in the National Library of Australia, but they're only accessible after 25 years. And particularly what gets up some people's nostrils is that it'll be 99 years before any of the personal records of the Royal Commission become publicly accessible. So there's a lot of concern about that. Next slide, please. I just wanted to briefly introduce the National Redress Scheme. Is it a legacy that the Royal Commission intended? It recommended a scheme, quote, independent of government, churches and charities, but the reality is anything but that. You will know that the scheme has those three elements recommended by the Royal Commission: a financial payment, counselling and direct personal response or an apology from the institution. But the scheme is actually based on a matrix devised behind closed doors with little or no reference to the Royal Commission's matrix recommended. It has a hierarchy of forms of sexual abuse. So whether or not you're a 5-year-old or a 15-year-old, penetration, contact, exposure, and the matrix guidelines are secret, so that when you make an application, you're not quite sure how those levels of or forms of sexual abuse are going to be interpreted. Next slide, please. And I'm nearly finished. states, churches and charities were invited to opt in, which is an extraordinary situation, with no sanctions for failing to do so. And it's caused long delays in processing applications. And this week, this very week, 2.5 years after the redress scheme started, we're still getting organisations joining or declaring they're not going to enjoy. As I said, the financial cap was reduced. Nearly all the differences between the recommendations of the Royal Commission and the actual scheme implemented favour the government and churches and charities. You might be surprised at that. Prisoners are excluded even though their offences related to their abuse as children. The Royal Commission made that very clear. Anyone sexually abused by a person under 18 is not eligible. It would cost too much, the minister said, to include these victims. Extraordinary statement. So, of the reporter anticipated 60,000 applicants for redress. As of this week, there have only been 9,900 applicants. 5,000 payments have actually been made, and 700 offers await an applicant's decision to accept or not the offer that's made by the redress scheme. So all in all, I think we can say that the scheme is a dismal flop. I might stop there.
Thanks for that, Frank. Yeah, that's pretty stark. Yeah. Hopefully, we can take the learning and from what has happened, like with the Australian experience and other experiences, and not make the same mistakes again. This is the thing that we're trying to do, that we know from experience what has worked and what hasn't worked. We have an opportunity now to put in place something that can work for the best way for the people that are most affected by it in Northern Ireland. Thanks for that, Frank. And we'll touch back on some of the points in the discussion. I'd like to bring in now Colin McGorman. Colin is the Executive Director of Amnesty International Ireland and founder of 1 in 4. And Colin himself was a victim of clerical sexual abuse and successfully campaigned to set up the Ferns Inquiry, the first Irish state inquiry into clerical sexual abuse. And he's been a close observer and commentator on the subsequent series of inquiries that have happened in recent years. And he's going to talk today and hopefully give us some of the lessons that can be learned from Ireland's inquiries and the good and not so good. So, Colin, you're welcome, and hopefully talk to us now.
Thanks very much indeed, Mark, and it's a real pleasure and an honour to be here. Very sobering to follow on from Frank's final points on redress, and I will touch on the Irish experience of redress towards the end of my own comments. First of all, thanks very much indeed to my colleagues in Amnesty International in Northern Ireland and to the University of Ulster for inviting me here today and for hosting these, what I think are incredibly important discussions, as a really significant contribution towards the process that's now undergoing to co-design a future inquiry in Northern Ireland. And I think that's the first thing I'd like to comment on is, the very fact that there is a commitment to a process of co-design is a remarkable departure from what we've seen in so many other jurisdictions. And it is enormously encouraging that the victim experience, the survivor and victim experience is so centred in the process of co-design. That is truly, truly, in my experience, groundbreaking. And I really hope that the executive follow through on what is understood to be the intention here, and that they don't just take the outcome of this co-design process as recommendations, but rather they take the outcome of this co-design process as a decision on the kind of model of inquiry that needs to be put in place. Now, all of that said, there's a huge responsibility and an awful lot of work to be done now on the part of those who are responsible for the co-design process and everybody who will participate in it. But you've got some fantastic people involved. So I think you're in a tremendous place to not just learn from what's happened in other jurisdictions, but actually to develop and build a model that shows the way of how we move forward from now on. just to talk a little bit about my own experience of these processes. As you mentioned, Mark, I was involved in the establishment of the Ferns inquiry in the first instance, and that was the first state investigation here into clerical sexual abuse in the diocesan context. And that then gave rise to further inquiries, the Dublin Archdiocese inquiry known as the Murphy Report, the Cloyne report that followed on from that, and others. So that was the way in which I was involved in those investigations. And then also, obviously, in my role in 1 in 4, I was heavily involved as well around the Commission to Inquire into Child Abuse, the Ryan Commission, which produced its report as well in 2009. And then in my role with Amnesty International in Ireland, obviously, from a human rights perspective, we've had an ongoing and strong interest and deep concern about inquiries in other areas. For instance, the failure of the state at this point to put in place an inquiry into the Magdalen home issue, and grave concerns as well now, finally, about the outcome and the final report of the Commission of investigation into mother and baby homes. In terms of what's worked well and what wasn't, I mean, I suppose the first thing to understand is that we've had a wide variety of different models. So the Commission to Inquire into Child Abuse was effectively based on a tribunal model, which was a highly adversarial model that was deeply flawed in many levels. The Ferns inquiry then was developed in an effort to avoid going down the route of the tribunal, because, for instance, the Commission to Inquire into Child Abuse took 11 years to complete its work. It was a very cumbersome, very challenging, very lengthy process. And whilst I think it's certainly delivered, if we want to talk about the concept of truth, justice, and reparation, which are the key human rights obligations on the state when it comes to acknowledging these past violations, we can say that the Ryan Commission produced truth in the context of it being systemic truth, right? And it set out very clearly the facts of what happened at the systemic level. It did not deliver truth in the context of individual people's experience. And that was one of the significant failings of how the state approached that inquiry. When it was first announced, the Irish state promised that there would be findings of fact in individual cases, something that, quite frankly, simply wasn't legally possible and should never have been promised in the first place. And that was the first real failure of victims and survivors in the context of that inquiry. Promises made that could never have been delivered, that were not delivered, and that subsequently caused very significant distress. I suppose that leads me on to a really critical point here, that, and I think it references much of what Anne-Marie had said earlier, that it's incredibly important that when we're establishing inquiries, we're clear about the purpose of those inquiries and what the outcome of them are meant to be. So, for instance, for many of us, when we engage in these processes as survivors or victims, we often see it as an opportunity for us to have our day in court, as if somehow it will provide some alternative to the criminal justice process, to a criminal prosecution, which of course it won't. And there can be an expectation that we will be heard and that our experience will be fully and publicly vindicated. And very often, of course, that is also not the case, because in many ways that's not legally possible if there is to be proper criminal accountability and prosecutions to flow from that. So it's really, really important, as Anne-Marie had set out in her presentation, that inquiries consider their purpose and what their outcomes are meant to be, and critically, who they serve. So if we think about a human rights-based inquiry and investigation, or human rights-centred one, it should put the victim, the survivor of the human rights violation, at the centre of the inquiry process. So it should be about ensuring truth, justice, and reparations for victims of human rights violations. And of course, it should also be about ensuring that there is appropriate and effective accountability. And when we talk about effective accountability, we're talking first and foremost about state accountability. So, for these violations to have occurred, the state clearly failed in its obligations to protect and fulfill the rights of the people who are subject to these violations. And that needs to be acknowledged and owned by the state. But then also the state has a responsibility to determine truth and to provide meaningful justice, so access to justice. But, that question of state accountability is a critical one. When we were campaigning for inquiries here in the Republic, the notion that somehow one of the first things we had to deal with, particularly in relation to the inquiries into abuse in the diocesan context, one of the first things we had to deal with was the suggestion that the state had nothing to say here. The state had no role. it was not appropriate for the state to be involved here. We had to deal with arguments that these investigations were constitutionally impermissible, because the Irish Constitution provided an assurance that religious organisations must be free to go about their operations, and the state wouldn't interfere in their operations. I mean, it was a nonsense suggestion, of course. But those were the kind of arguments that we had to deal with. And of course, arguments presented by the Catholic Church as well in the context of the inquiries here, that somehow canon law, the laws of the Church, were superior to state law, and therefore the Church could never be subjected to oversight or accountability through national or state legal mechanisms. So those were some of the challenges that we faced. But when we finally secured the inquiry, the Ferns inquiry looked at both, and the terms of reference were clear, that it needed to consider the knowledge that existed on the part of both the state and church authorities of the violations that were being investigated, and what they did on foot of that knowledge. So it really was to identify what were the systemic issues that led to and permitted the abuse to happen, at the same time as establishing the fact of what had happened in the context of the abuse. But of course, what was different about the Ferns inquiry, that there was no question of, at least in the terms of reference of the consideration at the time, there was no question of this leading to a redress process the state would be responsible for. Now, I think that meant that the state perhaps was slightly less cautious in the approach that it adopted in establishing fact, because it meant that there was no suggestion that the state would be on the hook or liable for compensation or reparations in the context of Ferns. That was the opposite was the case in the case of the Ryan Commission, for instance, where obviously a redress scheme was intended or foreseen as part of that process and had to be established in tandem with that process. But just because I'm very conscious of time, just in the context of redress, then let's talk about the Irish experience of redress, because thus far the only redress scheme that we can really comment on, because the others are deeply flawed still and have not delivered, is the Residential Institution Redress Board, which was established to deal with institutional abuse, and that's the abuse that was investigated by the Ryan Commission. I think it's fair to say that that process was one that was both brutalising of and brutal for most of the victims who went through the process. And some reflections I would offer are that in part that was because the operation of the scheme became more about minimising cost than about providing actual reparations. In terms of numbers, I mean, it's interesting when we heard the numbers from Frank. I mean, Amnesty International commissioned, we undertook a big piece of research in 2011, looking back at the Irish experience of these investigations, looking at Ferns, Murphy, Ryan and Cloyne reports. But if we look at the Commission to Requirement Child Abuse and the experience of industrial schools, there were just under 14,500 applications to the residential institutions redress boards. So a significant number of applications went through that process. If we look at how the process worked, it didn't make findings of fact. It effectively provided ex gratia payments of compensation based on a predetermined scale. You know, it set out a scale of impact that assessed the level of compensation that would be paid on a no-fault basis. The maximum level of compensation that could be payable was €300,000, but that could be raised by a further €60,000 in some cases. So the maximum amount paid would be €360,000. In fact, my understanding is that the average award was somewhere south of €70,000. And if we think about what was revealed by these investigations, we are talking about the gravest, the most systemic, the most serious human rights violations imaginable in the context that we're talking about here. Enforced labour, physical abuse, psychological abuse, emotional abuse, deprivation of liberty, sexual abuse, just horrendous abuse that, in our view, certainly amounted to torture, inhuman and degrading treatment. So really, really grave human rights violations. We know that the average compensation paid at the end of this was about €70,000. And then just finally on compensation, and maybe we'll get into this later on, I think one of the challenges is that unless an inquiry delivers meaningful responses for victims, and at the end of a flawed inquiry process, victims are channeled into a flawed compensation process that's purely focused on the payment of a financial sum, which is important. That is important. Reparation and restitution is important. But if all a process does is force people through a flawed investigation process, that then forces them into a minimizing redress process that results in them walking away with a check in their hand, that does extraordinary harm to people. Because yes, people want to be compensated, but people don't want to leave that process feel like they're being paid for their experience, as opposed to being compensated and acknowledged and given meaningful reparation and restitution because of their experience. And I mean, the redress board here, for example, one of the things that the redress board process did, under the guise of providing confidentiality for all involved and protecting the ex gratia element of, or the impact-based element of it, was it put the most extraordinary sanctions on victims who went through the process. They were silenced under a threat of a massive fine of, I think, €25,000 up to 3 years in prison if they breached confidentiality of the redress process. In other words, if they talked about either their experience of the redress process or the evidence that they gave before the redress board. So we ended up with a process that brutalized victims and survivors, that minimized their experience because the levels of compensation that were paid were fairly appalling, and that left a significant number of people then silenced utterly by that process under threat of further sanction. And I really will stop because I've gone massively over time, but that also, I think, then speaks to what Frank talked about memory and archive. Yes, we need to establish truth. Yes, we need to work to secure justice. Yes, reparation is important. But truth is something that needs to be secured not in a moment. This isn't episodic truth. This needs to be truth that's held in perpetuity. This is also about ensuring that we acknowledge what happened, that we then, as societies and as states, take responsibility for what had happened and understand our past and our responsibility for that past, but also have the courage to interpret our understanding of our present, because we got where we got as a state. Who we are as a state is reflected today is reflected in part by who we've been, and it shapes who we will be in the future. So, a lot of talk goes into, and we're in those discussions here now in the Republic on memorialization. And really what we need to be talking about is about conscience, about these reports as moments of significance from the perspective of our social, our collective, our state conscience. And one of the things we want to see here now in the Republic are sites of conscience being established that allow us to remember what had happened in a way that isn't just about memory in terms of looking back and saying, wasn't that awful? But that's also about acknowledgement and interpretation in perpetuity. So access to the records of these processes is incredibly important at the societal level. It's also, I think, critically important for survivors and victims to be at a point where people are told that the evidence that they gave is now sealed for up to a century, and they can't access it, and it can't be publicly accessed at the end of a process that is meant to be about truth. To me, quite frankly, personally, just seems not just hypocritical, but obscene. So I think those are some of the things that we might want to consider as you look at the co-design process in Northern Ireland.
Thanks for that, Colin. Brilliant to hear from you and your experience and the wealth of experiences you bring to this process. And same with Frank, and the same with yourself, Anne-Marie. Having heard all of what we've heard there, what if, myself as someone who's been through that system, I was born in Marion Vale Mother and Baby Home. I was trafficked over the border. The particular circumstances that have to be incorporated into Northern Ireland that were ignored by the Commission of Inquiry in the Republic was the fact that there's a cross-border dimension, that the church orders treated the island of Ireland as one entity, and didn't. Basically, I was taken from one jurisdiction and put into an orphanage in another by social workers. So it's not just church as summer investigation, but social care. I got my records there a few weeks ago, and it says I was accompanied by a social worker from the orphanage in Marianvale to Donegal, where I was taken and baby remained. So that's where basically it was a social worker from Northern Ireland placed me in a institution in the Republic. That shouldn't have happened. But you know what? And that was that. There was hundreds of instances like that. And that sort of that practice that was normalised right up until the 80s. We could look at what learning would you take from your experiences? Like you've been through these tortuous inquiry experiences, and what would you know advise the co-design panel now if you had what you had the opportunity now to say, listen, this is what I recommend to you. This, don't do this, don't do that. What would you recommend?
I think you may have meant that to me, Mark. Did you? Yeah.
Well,
So
any all this is
yeah.
a
So
question.
I
Yeah.
suppose one of the first things I'd say that in designing the terms of reference, I would really suggest that people should consider how the various parties of the process could seek to block an effective investigation. Because let's be clear about it, agencies that are responsible for organizations and indeed the state, when they're responsible for these violations, generally resist them coming to light and being properly and fully uncovered. And that's not me being cynical or negative. It's just a simple fact. I mean, these inquiries are won because people like you, Mark, and so many others, Frank in Australia and others, campaigned so hard to secure these inquiries. They are hard won. So just because we've finally secured a commitment to inquiry doesn't mean that at the institutional level, either the state or the organisations involved are now somehow going to be less resistant to an acknowledgement of the facts of what had happened. So it's really important to build into the terms of reference mechanisms that can be triggered if there is non-cooperation, and also to think about how the terms of reference can try and secure cooperation. And in that regard, I think that inquiries need to be as public as possible. I think that's critically important because institutions will behave very differently when inquiries are public. Now, clearly, that presents challenges around individual victims or survivors giving their own personal testimony, because quite understandably, many may not want to do so publicly. So that's one of the things that has to be considered. But I think that when it comes to examining at the systemic level what had happened, those inquiries need to be fully public, and the response of the institutions and the way they engage needs to be very, very public. I also think that inquiries should think about how they can report upon how the various parties are engaging in non-public processes. There should be some level of scrutiny or reporting on how that is happening, because it will hopefully limit the degree to which um, others will be. We talk about being defensive. It's about adopting an aggressively adversarial approach. So we saw in the Commission to Quarantine Child Abuse, for instance, people who went before the investigation committee who were speaking of their own experience could find themselves being cross-examined by 5 different teams of barristers. You'd have a team of barristers for the state, and there could be 2 different teams for different departments within the state, government departments. You'd have a team of barristers for the institution. You'd have a team of barristers for the congregation that ran the institution, and then you could have a team of barristers for the individual perpetrator or for a number of perpetrators. So you would see individual victims being subjected to incredibly adversarial, aggressive cross-examination by a significant number, and that's just unacceptable. That's what we mean when we talk about brutalization.
I think that's one of the things we're trying to avoid is re-traumatizing and reinforcing. This has to be acknowledging what happened, but not sort of reinforcing and compounding what has already taken place. So I think that's the idea of the hybrid in some parts of the inquiry being public, some parts being sort of private or being confidential. But that seems to be you know
But you could build into the terms of reference some sort of mechanism whereby obstruction or non-cooperation could trigger a somewhat different approach. An example of that would be, for instance, in the Dublin Archdiocese inquiry, when we were negotiating the terms of reference for that inquiry. Again, we decided to focus in on this diocese by diocese because we believe that if we tried to have an island of Ireland or even a Republic of Ireland-wide approach into every diocese, it would be so obstructed that we'd never get there. So we wanted a diocese by diocese approach that would reveal what was happening systemically. Because what happened in one diocese was happening in another. That was the approach that we adopted. But equally, we didn't want to somehow allow for further investigations to not happen if necessary. So one of the mechanisms that we negotiated was that if it became clear that the Catholic Church, because that was the agency that was the subject of inquiry, so that could apply to any agency, wasn't effectively either implementing state guidelines or child protection guidelines in the context of how it dealt with past abuses or abuses within that, that would trigger a full inquiry investigation into that diocese. And that's how the investigation of the diocese of Cloyne came about. It became clear to us in 1 and 4 that that was not happening in Cloyne, and then we were able to use that mechanism to secure a further investigation in Cloyne. So thinking about conditions within the terms of reference that could trigger a more significant approach or significant intervention should non-cooperation or should any parties to the inquiry begin to conduct itself in a way that obstructs the inquiry is one of the things that might be considered.
Okay, then thanks for that, Colin. Frank, have you any thoughts on what worked well and what maybe didn't work well from the Australian perspective?
If I can comment first on the issue of courtroom behaviour, there was a kind of a tacit agreement that lawyers who were plentiful within the hearings, 20 or 30 lawyers sitting at benches representing their respective clients who were under scrutiny, there was a general agreement that they would not go hard on survivors, that they would take it easy. There would not be aggressive questioning. There was only one exception to that, and that was George Pell. He, the leading Catholic figure in Australia, broke that protocol. So that was, I think that was a very positive thing, that people could go into a hearing knowing that they would give sworn evidence, but they wouldn't be attacked by a solicitor or a barrister. There were plenty of barristers there, so it wasn't necessarily an easy experience for people. I think the choice of case studies was a mixed bag. As I said, there was a predominance of church-based or faith-based, as they termed it, case studies selected by the Royal Commission, and they didn't really, I think, give a satisfactory rationale for why they chose this one and not that one. For example, in Ballarat, obviously they went for the Pell situation, where Pell lived with a number of pedophiles and said that he knew nothing all that time, and there was that was probably the most news attractive hearing. But in the Ballarat city, there's the Ballarat orphanage where I was a child, and that had a number of superintendents who were pedophiles. The Royal Commission refused our request to do a case study on the Ballarat orphanage. And the only reason they gave was, well, we don't want to interfere with court proceedings that might happen outside the Royal Commission. As it turned out, there was a prosecution of one of the superintendents, but it's been abandoned because he is regarded as not being well enough to face a trial. His name's been scrubbed off the honour board in the Ballarat, in the remnant Ballarat orphanage. So he's no longer persona non grata, along with two other senior officers of that institution. So I just give that as an example that comes to mind, but there are many, many complaints about why this institution was chosen and why not another. It was galling to care leavers to see the attention given to Swimming Australia or the Scouts or the Girl Guides, or where there were terrible abuse happening, but in the total scheme of things, one felt that undue attention was paid to situations that didn't warrant a full hearing. It could have been done in some other way. So I would say that negotiation with the commissioners in our situation should have been a bit more open and transparent, and justification of why this situation represented an important enough situation to warrant a hearing, as against others that didn't warrant a hearing, I think could have improved the situation. In the case of private sessions, the 8,000 or so survivors or victims of sexual abuse who that was a voluntary situation. So anybody who had a story they wanted to tell could go to the Royal Commission and they would get through that. It took a long time, 5 years. And I think at the end of the day, there were still people who hadn't been heard. But at least that was a voluntary situation where the survivors were in control. If they wanted to go to a Royal Commissioner, they could go to the Royal Commission. If they didn't, they didn't. There was no pressure on them. So it's a mixed bag.
Yeah, it's the birth mothers and the Children for Justice have been campaigning for years to get to this stage where we're at now with the potential for an inquiry, and people are anxious to get it right, to get, and like one of the things that people I'm hearing is, how do we connect with people? Like there's like my own mother, I found out quite recently, she left Ireland shortly after she had me because of the shame and the stigma. She went to England and she passed away. And there's thousands of women that have come through these systems that are, they're aging, they're getting older. How would you what do you think is the mechanism for connection with to get people to engage with this process or this inquiry?
Yeah, that's a big issue. I mean, I don't want to hog the conversation, but it's certainly playing up in the National Redress Scheme in Australia, where people are dying. My own brother, a month ago, died on the day he put his submission in to the redress. And he's not unusual. There are lots and lots of older people, in their 80s and even 90s, who are making submissions and being held up in the process. The redress scheme says we take account of people's health and frailty, and we put them into a fast queue. But there are some people who are still waiting 3 years to have this is their third year of waiting in that queue, and we keep records of all the care leavers that we know who have made application for redress, and we know that the claim that the old elderly and the frail are being given speed treatment is just not true. But it's an ideal situation. You simply could. I mean, there's nowhere on the application form for anyone to indicate their health status. That's a dead giveaway that they're not really serious. You have to actually ring up. We have to ring up as an advocate and say, look, so and so is 86 and has cancer or whatever. Can you please fast track their application? We've had applicants who've died very shortly after they've got their redress payment. They won't be able to take advantage of the counselling, or they won't certainly get an apology from the responsible institution or pedophile.
Two quick things on that, if I could, Mark. Firstly, I think linking counselling and therapeutic supports are responsible. Health services to survivors and victims to redress is simply not on. And the state should be ensuring that there's access to health services that all survivors and victims need, just as a matter of course. It has that obligation in respect to vindicating people's right to health, and it shouldn't be linking it to a redress process. That must be provided, and in my view, it should be entirely separate to the redress process. And then finally, we really have to question the bona fides of the state or the good intention of the state if it's not proactively putting in place a process that people can easily access. So, for instance, it should be resourcing organizations that are working with survivors and survivor-led organizations so that they can support survivors and victims in coming forward and being able to access redress systems effectively and efficiently. And then critically, it should be put in place resources to ensure that redress applications are processed in a timely and efficient manner. The fact that people have waited decades for truth, never mind for justice or haven't secured justice, reparations should be provided in a really timely and effective way. And the state really, we've heard from Frank how the state says, well, we couldn't compensate people who are sexually abused by people under 18 instead because that would be too expensive. You have an obligation to provide redress and reparations to victims of human rights violations in this context, regardless of who the perpetrator was, and because you failed to protect them from those abuses. And the fact that it's expensive, you don't get to put a limit on justice or reparation to people because you've decided there's a dollar limit on what you're prepared to spend on this. So systems and resources have to be put in place, and that's, I think, absolutely critical, and it's clearly not happening in many cases.
Yeah, thanks, Mark. Well, for me, sort of a number of takeaway points from what we've all said, and I think we're in agreement, things like terms of reference, how we define things, what's included, what's not included are important. And in terms of your point, Mark, or your question in terms of how we get people to engage with this, all the usual mechanisms I'm sure will be used, websites, advertising, but I'm not a survivor, so I can't speak from the survivor perspective, and I acknowledge that limitation. But to me, that has to come from survivors themselves. Some people, as you've mentioned, maybe have moved on to a different extent or not with their lives, and maybe their families don't know about some of this, and they don't want this. So there are all those sorts of difficulties. The other probably takeaway point from what we're all saying as well, from me and from my own research and experience, is that we need to think now beyond the inquiry. So truth is only the very first step. There's all sorts of arguments around sequencing and, whether you start redress now to put it in parallel, or do you need to know what you're compensating or repairing for? And I think you do. I think truth has to come first. But we need to think very much now, bearing in mind the ageing population of some survivors. We need to think beyond the inquiry now, what's going to happen afterwards. I think Colin put it well in terms of this link between truth and justice and reparation and memorialisation. So all those sort of public law principles of accountability and redress, we need to try and think now beyond truth and get our heads in gear so that when we do have truth, and however long this takes, we're not left then flailing to say, well, what do we do about this with what we know? And equally, just last thing following on from this, I think that Colin's point as well about, you can't give with one hand and take away with the other. You can't have an inquiry that's going to cost a lot and cost a lot in human terms, in terms of survivors having to give evidence and the trauma of that, but then say, and by the way, we're sealing all this for the next 100 years. So if we're serious about the public law principles of accountability and transparency and redress and cooperation and fairness and openness, that's part of it as well. Let's put the cards on the table and do this in a proper way.
Thanks for that, Anne-Marie. And I'd just like to acknowledge and thank all of our speakers here today, Frank, Colin and Anne-Marie, for their significant contributions. And acknowledging the fact that we in Northern Ireland now have an expert panel with members of the Truth and Recovery, which have recently been appointed, and they have basically pledged to work closely with victims and survivors to recommend the most appropriate form of inquiry. So we'll see what way that works out. But we would encourage people out there to get involved in this process, and the details on how to contact will be at the end of this video, as well as the details if you want to make contact with Amnesty at the University of Ulster. Again, thanks to Frank, Colin, and Anne-Marie, our speakers, and please look out for other events in this series. And let's make sure that this issue. We learn from the mistakes of our past, and we make this going forward, this co-design process and this inquiry, whatever shape it may take, be the best that it can be for the people that are infected.